Namaste everyone. Myself Mukunda Saiyam and my teammates are Madhusudan, Sundar, Bharat and Prabin. Today we are going to explain about e-contracts and legal validity in India and challenges in the digital era. So let me introduce about e-contract. E-contracts are an agreement created and communicated and finalized using electronic methods such as emails, mobile applications, website and other online platforms. It is not like a traditional paper contracts. They do not require any physical signature or paper documentation. Everything happens digitally. And it is important because we can see in COVID-19 where the business are forced to move on online operations and physical meetings became rare. Online transaction and agreement becomes the norm and all, and from sales to service contract everything shifted to the electronic modes. And the growth of digital economy also took place where industry like e-commerce, Amazon, Flipkart and fintech industry like Paytm, PhonePe and freelancing platforms which work like Upwork, Fiverr and cloud services also like AWS and Google Clouds heavily rely on the e-contracts for user agreements and vendor contracts and service terms. So it is beneficial because it took like it is a faster transaction and there is no like cost, like because there is no any printing required and all, and there is no any courier also required, and accessibility from anywhere, and environmentally friendly also because there is no any use of any paper and documentation and all, so it is paperless. And if we see like types of e-contracts, before going to that, as I said, e-contract is an agreement created and communicated through all digitally. There is no any face-to-face meetings and all. There is a key elements like offer acceptance and consideration are exchanged digitally through emails, website, mobile application, or specialized electronic platforms also. And e-contracts are legally valid if they meet the requirements laid down in the Indian Contract Act 1872 and are also recognized under the Information Technology Act 2000. And there is a types of contracts, e-contracts. First one, click wrap agreement. This refers that user must actively click an I agree or else accept button to consent the terms and conditions. For example, for installing software like Microsoft Office or Adobe Readers and all, where they must agree to the license terms before proceeding. And second one is like shrink wrap agreements. Here, this refers that contract terms are included inside the product packaging. By opening the package, the user is considered to have accept the terms. For example, buying softwares in CD DVD package, where opening the seal implies that acceptance of license terms inside. And third one is like browse wrap agreements. This refers that terms and conditions are provided via link on the website, but the user is not required to actively accept them. For example, terms and service or a privacy policies linked at the bottom of applications like Amazon, Facebook, and Netflix also even. And fourth one is like email contracts. Here, this refers that offer and acceptance are exchanged through emails between the parties where there is no any physical meeting is necessary, and the email trail itself can form a legally enforceable contract. For example, a freelancer agreeing to work for a client after negotiation terms via emails and all. And next will be explained by my teammate Bharat.
I am Bharat. I am going to explain about the key challenges in e-contract. First is identity authentication. Proving the true identity of the parties involved in an electronic contract is complex and critical. There is no physical interactions or handwritten signature to verify who is actually entering to the agreement. E-contracts are formed through digital with emails, addresses, username or digital signature acting as an identifiers, but these digital identifiers can be easily faked, hacked, or lead to possible fraud in the contract. Next is types of authentications, like digital signatures, like cryptographic mechanisms used to authenticate the identity of the signer. However, that is not till widespread. And next is multi-factor authentication, provides additional layers to verify examples like OTPs, biometrics, but still lead to hacking. Example like if one party signs an agreement with a fake email or something else, the authenticity of the contract can be questioned. Next is consent issue. Consent is a foundational principles in contract law. In electronic contracts, consent is often implied or passive rather than actively given, which can be causes comprehension when it comes to enforcing contract or resolving disputes. Active versus passive consent. In traditional contracts, both parties must explicitly agree to the terms in e-contracts. Particularly browse web agreements, user may be bound to terms simply by browsing a website or using the service without actively clicking on an I agree button. And the passive consent may lead to a situation where the parties did not even read the terms or unaware of the conditions. The types of consent is click wrap agreements. User actively clicks I agree, clearly showing the consent. Browse wrap agreements. Terms are made available, often the button of the web page or in a pop-up, but user do not actively express the consent. Example like a user who simply visit a website without realizing they are accepting the terms of the use might later dispute the validity of the agreement, claiming they did not consent properly. And next is jurisdiction problems. Jurisdiction refers to the legal authority to resolve disputes in traditional consent. Jurisdiction is a typically clear where the contract is signed, where the parties are located. However, e-contract often involve parties from different geographical locations, making it unaware where the contract is considered to have been formed or where legal disputes should be adjusted. In case of disputes, courts or regulatory bodies need to know why country or region's law apply. Lack of clear jurisdiction in one party is in India and other is in US. Both countries' legal system may claim authority, leading to potential conflicts or confusions. Factors influencing jurisdictions like locations of the server. Some contract may specifically where the service or product is provided, which could influence the which could applicable jurisdiction. Choice of law cause. May e-contract have cause specific the which jurisdiction laws govern the agreement. Example like if an user in India purchase a product from the website hosted in the US, the jurisdiction question may raise if there is a dispute regarding the product delivery or the quality. And next is privacy and data protection. E-contract often involve the exchange of sensitive personal and financial information such as names, addresses, bank details, etc., which raises serious concern over the data privacy and security. Lack of comprehensive data problems. While India's Information Technology Act 2000 covers the certain aspects of data protection, there is no comprehensive data protection law in place yet. The personal data protections based on the European Union's GDPR is still under the review and has not been fully implemented. The risk of data breaches, like sensitive information can be hacked, misused, or sold to third parties without consent. Global consent, like international businesses might have to comply with the data protection laws of other countries, such as GDPR in Europe, creating confusions about with data protection has applied in cross-border transaction. Example like in 2020, Facebook backlashes due to privacy concerns with Allegations that personal data was shared without consent. This raised the question about how e-contracts should be enforced in personal information in the mishandled. Overall summary of the challenges, particularly in digital era where the electronic communications and transaction continues to grow without the proper safeguard, identity authentication, clear consent, judicial clarity, and data privacy protection under the efficient and trust in e-contracts.
Myself Sundar. Now I am going to explain about recognition by courts and evidence admissibility. Important case law. Trimix International FZE Limited, Vedant Aluminium Limited at 2010. Facts. Negotiation happened via email between parties for selling goods. No formal written contract was signed. Supreme Court held an email exchange where offer a acceptance or clear consistence a binding contract. No need for formal physical signature if intention and agreement are proven. Next one is Tamil Nadu Organic Private Limited vs State Bank of India at 2014. Facts. Dispute over loan agreement made electronically. Court upheld the validity of electronic acceptance throughout emails and electronics communication, and emphasizing that modern transactions increasingly rely on technology and court must adopt accordingly. And evidence admissibility of e-contract. Electronic records including emails, PDFs, electronic signatures and website logo are admissible in Indian court under specific condition. Section 65B of Indian Evidence Act 1872, electronic records are considered secondary evidence. To be admissible, a 65B certificate must be submitted. This certificate confirms that the electronics records was provided by a computer regularly used during the ordinary course of business. The certificate must decrease the process by which the data was produced and affirm its integrity. Thank you.
Hi, I am Madhusudan. I am going to explain about global perspective and technological barriers. UNCITRAL model, Law on E-commerce 1996. The United Nations Commission on International Trade Law created a model law in 1996 to help countries make laws about e-commerce and e-contracts. It promotes the use of electronic communication in business and recognizes that contracts can be formed by exchanging emails, electronic documents, or other digital methods. The model suggests that electronic documents should be treated the same as paper documents in courts. Many countries, including India, have used this model law as guide to create their own e-commerce laws. Our second one is USA e-Sign Act 2000. Electronic signature in Global and National Commerce Act. In the USA, the e-Sign Act gives electronic signatures and electronic contracts the same legal effect on handwritten signatures and paper contracts. The Act says a contract cannot be denied just because it is electronic. It helps boost online banking, online shopping, and other digital businesses in the US by building trust in electronic transactions. Third one is UK Electronic Communications Act 2000. The UK Electronic Communication Act also recognizes electronic signatures and digital contracts as legally valid. It encourages the use of encryption and secure digital communication. The law supports online business and e-governance by making it easier to sign documents and make agreements electronically. Next is technological barriers, problems in using e-contracts. First one is digital divide in India. Digital divide means that not everyone has equal access to the internet or digital technology. In India, many rural areas still suffer from poor internet connectivity, lack of smartphones or computers, and digital literacy. As a result, While people in cities may easily sign e-contracts, people in villages may not be able to use digital platforms at all. This gap limits the reach of e-contracts and creates inequality in access to digital business opportunities. Second one is cyber security threats. E-contracts face a serious cyber security risks. Some major threats include hacking. Attackers can steal or change electronic contracts by breaking into systems. Fake signatures. Cyber criminals can forgo digital signatures to cheat people or companies. Data breaches. Personal and business information shared in e-contracts can be leaked or stolen. These threats make people afraid to fully trust e-contracts, especially when sensitive information or large amount of money are involved.
Hello everyone, myself Praveen. I am explaining conclusion. E-contracts have become very important because more people are buying, selling, and making a agreement online. They are essential for the business like e-commerce, fintechs, online freelancing, and many other. But even though e-contracts are useful, there are many problems. It's hard to prove how really signed the contract. Sometimes people agree without really understanding what they are agree to. It's unclear with countries. Cost will be solve problem if difficult happens. Data privacy is a big worry because there's no strong law in India is to fulfill protect people's personal data. So well e-contracts are future will be still have a legal and technical challenges to fix.
So guys, this was the e-contract and legal validity in India and challenges which are faced in the digital eras. So if in case there is any questions and there is any doubt, please comment below. Thank you so much.